regulation, that is insider trading, judicial decision shaping the law. This is our 91st webinar and our spread of knowledge sharing, which we have started 2 years back. We want to thank all of you joining for this journey and encouraging and motivating us in our knowledge sharing endeavor. Friends, this webinar is the 5th webinar on the topic of insider trading. In the four webinar held by us, over 100 questions were received from the participant, and this prompted SEBI to come out with a FAQ on this subject. And this FAQ contains each and every topic issues which people have raised, and we have collected, and SEBI has received from their own sources also. To protect the interest of securities market and to ensure equal opportunity to the investors, the insider law are enacted to almost all the securities market structure in the world. While the Indian law on insider trading is also envisaged with the set serious and risky objective under the unique 3-tier governance structure with listed companies and intermediaries and its foundation. Under the overall supervision of Stock Exchange and SEBI, the law ever remain an integral topics of discussion amongst professional, corporate and regulator for its reach, regulation and rigors. The recent legal and judicial development in the field of law tend to create a discussion even more, as they pose definite changes in the way the law has been understood and applied. Friends, the objective of today's webinar is to analyze and deliberate on these judicial and legal development and take the view from the industry and the regulator on this subject. Today, the key area of discussion will be reach, ambit of insider law, who all are governed and how. That is very important because that question again and is coming, that who all are included. Regulation, implementation and administration of insider law, where we have reached and how far we must go. That is a part of the regulation, and the regulator continuously updating this. So we want to understand this. Rigorous, how sharp the sanction of insider law, what are the safeguards for innocent? Because it is not correct that every person who is doing trading is an insider. He may be insider, but has he done insider trading? That is a question. So that's a question for both the culprit as well as the innocent. Friends, the SEBI PIT regulation puts in place a framework for prohibition of insider trading in the securities. Taking a cue from this, whatever there is any doubt on the applicability of the regulation, we should take a conservative interpretation, keeping in view the use of word of prohibition. We have a galaxy of experts today. Before I invite them to make their presentation, let me perform the pleasant duty of briefly introducing the learned speaker. We have from the regulator side, Kranti Sardesai. She is Deputy General Manager in the Integral Surveillance Department of SEBI. For the last over 4 years earlier, she worked with the Investment Management Department, Mutual Fund, and in the Office of Investor Assistance and Education. She actively worked on insider trading front-running cases and surveillance policies, has wide experience with policy matter on mutual fund, change in control of mutual fund, etc., as also on fashioning the overall investor education financial literacy framework. She achieved merit position in standard 10th, 12th. She is a graduate in economics and MBA in finance from Pune University Management Department. I welcome Kranti for this program. Welcome for our program. Then we have very learned speaker Savitri Parekh. She has more than 25 years of corporate experience and currently company secretary and compliance officer of Reliance. She has worked in the variety of sectors, including manufacturing, outsourcing service, private equity, media, pharmaceutical, textile, and chemical. She is a specialist editor of Ramaiya, a guide to Companies Act, and general editor of MC Bhandari, Guide to Company Law Procedure. She is the chairperson of Corporate Governance Committee of Bombay Chamber of Commerce and Industry. I welcome Savitri for the program where you have already contributed so much in the PIT regulations in the past also. Then we have Mr. Pankaj Tiwari. He's a member of ICSI, graduate in law, over 20 years of experience. He is associated Bharti Group as a group company secretary, acting as an advisor to the board of directors, and is responsible for ensuring high standard of corporate governance across the group. He has supported various corporate transactions, including various fundraising initiatives, merger acquisition, corporate restructuring, overseas listing of Airtel Africa. He has engaged with regulatory representation of companies at various fora. Then we have Pankaj. Before joining Bharti Group, he has associated with PwC as a director and worked extensively on corporate governance and compliance space. He has the experience of working with senior board on board of governance, effectiveness, and evaluate various things. Prior to PwC, Pankaj has worked in various industries as a company secretary and legal department. He is a member of Committee of Corporate Law, Regulatory Office of CII, FICCI, and PSG Chamber. He has been extensively involved in various initiatives of public advocacy through leadership. I welcome Pankaj for this program. Yesterday he was not well, but because of his dedication and commitment, he has joined. So we will definitely get benefit of his experience.
Thanks, everyone. Good evening, everyone.
Yeah. So then we have Mohini Vashne. She's a Master of Commerce and fellow member of ICSI, possessing 17 years experiences. Presently, she's heading ESOP and SEBI Insider Law Compliance Division of Corporate Professional. She's expert in providing end-to-end solution of all kinds of share-based employee benefit and in-depth advisory, opinion, education on technical issues to the board and other employees on insider trading. She's instrumental in developing group of web-based application, ESOP Guardian and Insilis to comply with SEBI provision and insider trading regulation 2015, running successfully in various companies. I welcome Mohini for this program. Then we have our budding professional Ravi Prakash. He's an associate partner at corporate professional. He's a research-oriented professional and has extensive first-hand experience over 6 years in corporate and securities law, representing many prestigious clients before SET and SEBI. He thus has a vast knowledge of insider and securities law to draw upon these matters shaping across securities violations, shareholder dispute, and white-collar crimes and other contentious issues. So friends, these are I welcome all my learned speakers. They are working day and night in the security law insider trading. So today's program structure will be like this, because our topic is judicial decisions shaping the law. Because what is happening, law is there, but so many cases recently SET has passed, Supreme Court has passed, that has given a new dimension to the interpretation of law. So we want to discuss these new development. We want to hear the regulator also, that what is her view or the SEBI's view and what message they want to give, and what is the philosophy behind this insider trading regulation. Then we have Ravi, who will discuss about the 6 cases which are passed by various courts and which are giving a new dimension to the insider law. Then we have 2 stalwarts of the industry, Savitri Parekh and Pankaj Tiwari. They will share their experience on this topic. And they will also, because when they are implementing this law, they are facing problems, they can share. And at last, because as you are aware, SGDN is compulsory now. You have to keep digital database. And Mohini will discuss about the digital database, its implementation, and how this particular thing can be used by her experience. So friends, without taking much of time, I will request Madam Kranti Sardesai from SEBI to discuss. And in the meantime, all participants, they can write down the questions, they can pass on to us. And after the presentation of all, we will have a question answer session and we will discuss. Over to you, Kranti, please.
Thank you. I hope I'm audible.
Yeah, you are.
Okay, let me share my screen first. Hold on. Is it visible?
Yes, you can just expand. Yeah, it's perfect.
It's perfect. Oh. A very good evening to all of you assembled here, assembled in IT space, if I might use that word, and as well as the rest of the illustrious panel who is here with me sharing the virtual dais in this particular program. Now, thanks are also due to Mr. Pawan and his team in corporate professionals for having given me the opportunity to address all of you for this particular topic. This topic is extremely close to my heart. Having worked on quite many cases in insider trading and worked in the integrated surveillance department for this time, this is one topic for which I'm extremely passionate about. Without any further ado, let me start on my topic. The subset of the topic given to me is PIT regulations. What is the surveillance system of SEBI, and what are the expectations from the industry? It looks a bit formidable, but I think we'll make it interesting as we go along. Okay, so let me go into theory a bit, boring theory a bit. How did the insider trading regulations evolve? It's been quite a process because the 1992, the erstwhile regulations were mostly on the basis of the Abid Hussain committee. I forgot to write it here. After that, it assumed a new form, a new avatar, so to speak, in the PIT regulations of 2015, based on the NK Sodhi committee, and wide changes, additions were brought about through the Vishwanathan committee report, based on the so-called Fair Markets Committee report in 2015. So there have been many changes, many amendments, but these are the broad contours of what really happened while fashioning the insider trading regulations by the regulator. Now, as for the applicability, who is it applicable to? I mean, who is the regulations addressed to, if I might? It is addressed to listed companies. There was some confusion. I don't know whether it is applicable to companies whose debt is listed or not. So I guess the jury has been out and the answer is there. It is applicable to both equity and debt listed companies, one. Then we have 2B listed companies, those who have filed their documents with SEBI expressing their intention to get listed. The next set is intermediaries, the section 12 of the SEBI Act intermediaries like brokers, DPs, etc. And the last but quite an important facet is the fiduciaries, those individuals or institutions which are, fiduciaries, let me give an example. Those are big accounting firms, law firms, consultants like corporate consultants here. These play the role of fiduciaries, and intermediaries and fiduciaries are specifically included by virtue of the role that may have in their contact with companies, in their constant contact with companies by which they may get access to UPSI. Now, the regulations are quite comprehensive, but in essence, what is the one message that the regulations are trying to give? That essence of the regulation can be found in Regulation 3 and Regulation 4. It gives, and all the other duties like the code of conduct, the code of fair disclosure, and all the schedules, all the parts, aim towards this end, Regulation 3 and 4. What does Regulation 3 say? Don't communicate UPSI, and Regulation 4 says don't trade while in the possession of UPSI. So these are the two main things that the regulations seek to achieve. So non-communication means what? That an insider should not communicate, provide, or allow access to UPSI relating to a company or its securities, as per the definition of UPSI, to any person, including other insiders. And so the same responsibility is placed on any other person who possesses, that he should not procure UPSI from any insider. He shall not cause communication by any insider of UPSI, again relating to a company or securities. But there are notable exceptions to this rule, and the exceptions are procurement for discharge of your duties, your legal obligations, or for legitimate business purposes. So, if I might, this is the heart of the insider trading regulations. Two don'ts. Don't do Regulation 3. What is stated in Regulation 3? I mean, you follow Regulation 3, don't communicate UPSI, and Regulation 4, don't trade while in possession of UPSI. So, these are the two cardinal instructions, if I may, that the regulations give, and all the other disclosures, all the other codes of conduct, etc., are means to this end. This is the grand goal that we are set out to achieve. Now, let's discuss a bit about why we are all of us are so hung up about insider trading. what is this in this particular act that poses such a menace? If I might go back a little in history, the SEC was one of the first regulators to enact this act, the Securities and Exchange Act, which outlawed insider trading. And in US, Mr. Arthur Lewitt, who was the chairperson of the SEC, once made this assertion, a very strong assertion, that insider trading does not have any place in a civilized society. But ironically, it is this civilized societies, the US's, the India's, where we see corporates flourishing otherwise, that we do see also cases of insider trading. So what Mr. Arthur Lewitt acknowledged way back has no, we have not yet found a solution as to how to curb this menace. I don't know how many of you have read this very interesting case. I'm just diverging a bit from the main topic, the insider trading case on shadow insider trading in the US. That was a very interesting case, and that widened the ambit of insider trading even more, which states that the UPSI pertains to company A. The short story I tell you in a couple of sentences was that Pfizer took over a smaller company, and which naturally increased the price of their smaller company in the market. But what the accused had done, he did not trade in company A. Let's call it company A. What he did was he traded in company B, which was a peer of company A in that particular industry. And the trade was with the expectation that since so many few companies were the suitors for takeover, if we can call it that, were left in that particular industry, that would increase the price of that particular company, and it did. He traded heavily in call options and made a lot of money out of it. And SEC passed the order, I mean, we're taking action for insider trade. So here we are talking about safeguards, but here we are also saying that regulators worldwide are in a way widening the ambit to include this for insider trading, and precisely because why is insider trading bad? Because in a way it rewards information asymmetry. Natural information asymmetry will realize we cannot have the perfect market of economics anywhere, but if it is rewarded and unpunished, let me say, if it is unpunished, it is very, very bad to the underdog who does not have such privileged access. So in a way, we are not to sound socialist, but we are upholding societal privileges and penalizing for underdog just because he is denied that privileged access that others have. So this is the feel for the underdog that lets us to treat insider trading in an extremely serious manner. Okay, now the theoretical bit is over. We come to the practical bit. How does SEBI sniff out leads? I have no doubt many of you would be interested in knowing that with all these cases and orders that SEBI has passed earlier and even in the recent past, how does SEBI get leads for these? These are the various sources of leads, in-house alerts as well, designed by us and improved over time. Then we have complaints, scores, and otherwise. We also have the exchanges who have their own alert system and provide red flags, examination reports to us in which we dig into further if required. Then we have references from external agencies like the Enforcement Directorate, etc., which may lead us to other leads in PI. References from social media, yes. Tweets. Somebody saying that the prices increased in this so much, it needs to be looked into. Not that we will take every tweet seriously, but if we find something that worthy of seeing, we do look at social media references as well. Then for getting information from whistleblowers, we have the Office of Informant Protection within SEBI. That is one more area where people who are otherwise hesitant to make complaints with their name can come anonymously and make but this office has a very, very structured way to it. You can't just say that I don't like this person, he looks as if he has done insider trading. You have to come out with a whole set of evidences or at least supporting facts supporting our assertion. So we have the Office of Informant Protection. We also have this thing about informal market intelligence. Informal market intelligence in that way is a double-edged sword. It may it may be more misleading than useful, but it does throw up a few leads that we follow. Now, let me give you a very interesting example. Most of you would be knowing the Infosys 2 case, not the Pranshu Putra one, the other one where the Vanguard deal was being talked about. Right? So, what I'll do is, I'll show you what kind of number crunching SEBI does. what we are showing here essentially is that this was not Keyur Maniar's usual way of trading. His favorites were other stocks. But in July 2020, what happened is this news of the Vanguard deal broke out on the 14th, if I recollect correctly. So if you just see the movement, I hope all of you are broadly conversant with what delta is. It has been explained quite at length in many of the SEBI orders. It essentially means how your derivative positions move in relation to the movement in your cash position. Net, this is the story. So, for example, if this position has a delta of 180, 1 rupee movement in the underlying cash. Suppose, since Ms. Savitri is here, let me talk about Reliance shares. If 1 rupee movement is in the underlying Reliance share, would move the future or the options position essentially held by a person with the portfolio delta of 180 by rupees 180. This is the power of your derivatives. So what I want to show you in this chart, let me talk while I'm showing you the chart. This is you can see the daily movement in the delta positions of Keyur Maniar across scripts from January. Here you can see the date, here you can see the total delta. Yeah. So you can see the most favorite share. Here the maximum delta position in his portfolio is 14,500. This is in February. Hold on and see how it comes. I think I'll move it a little further. Basically, the story is that he's always been holding this particular stock. You'll see. I'll turn it. This shows the movement at a particular point of time. Let me move it a little further. Yeah. So we are in April now. So see, the highest delta has remained more or less constant for a long time. For 51,000 odd in TV18 broadcasting. That has been his regular favorite. Yeah. So here we see him normally trading and he's been holding it for quite some time. So that is probably a share on which he's done some research or something like that. Now let us see where Infosys will come. So again, this delta moving. Here you can see an Agantuk coming in surreptitiously. And you just see how the position increases in July. See, it shot up. It shot up to a 51,000 was delta and it shot back again. This is the message which we wanted to bring. Which is, many of you may have seen this chart in the Infosys order itself. I don't know whether you have. Have you, Mr. Pawan?
Yeah.
Yeah. So the message that this chart carries is that there is normal versus abnormal behavior. If we just see normal behavior, he's been investing in a wide variety of scripts, but TV18 broadcasting holding pride of place for quite a long time. But the Agantuk Infosys comes in and jiffy it leaves after having done its job. So this is the kind of number crunching that SEBI has to do while looking at normal versus abnormal behavior. So what you see is the order, but what maybe the order may not convey the huge number crunching, huge background work that has gone into it. Let me go into another example. The Lux Industries case. There's we have taken action against 14 entities. The alert had not come in all 14 entities. The alert had come in some of them, but we joined the dots. This was one major entity in this stock, and the insider was Mr. Udit Todi, who was the son of the MD and an executive director himself. So we traced back his calls that to his father. We first found the suspect in the stock. Then we found that the Indus stock is but a company of his wife's family, Mr. Sanjeev Bubna is his father-in-law. And we also saw Mr. calls between the insider and the suspect. We also saw calls between the suspect and his daughter, that is the insider's wife, on the very same day on which he placed this order to buy the share. Incidentally, it was Mr. Father-in-law who placed the shares for the group company on behalf of the group company. So he was acting on behalf of the company. So essentially, they were his trades. And this was the easy joining of the dots. For the rest of the suspects, we had to go layer to layer. For example, this is the insider. We went to Mr. Akshay Kapoor. He was the main link who kind of disseminated UPSI to the Somani family, so on and so forth. So what are the evidences we have? We have mobile calling, we have messaging, we have bank transfers. So joining the dots is a very, very laborious process, let me assure you. We have also looked at a trail of phone calls. Again, the insider is talking to two of the suspects. One of the suspects in turn is talking to the rest of the suspects who belong to one family. Of course, this cannot be evidenced by itself, but supported by a lot of other facts like trading pattern, unusual trading pattern. I showed you the example of unusual trading pattern in the earlier emphasis. That taken together with these connections makes a very compelling, case indeed. Now, I have gone into a bit of a theoretical framework on insider trading. I've also gone into how SEBI works, how SEBI, what are the efforts put in by SEBI on such cases. Now that I've placed some amount of proof on the table that SEBI is doing its bit. Now I want to go to the sort of preachy part. What are the expectations from the industry by SEBI? One thing is zero tolerance policy and vigilance towards the possibility of insider trading. This may sound a bit harsh, but I'm not talking from a moral ground. Let me put it this way: image consultants would agree with me that companies, leaving aside the moral rights and wrongs, should do it in their own interest, because the image of the company that takes a beating when it is caught in the sense its name comes in unsavory context of this sort is not very good for the company. So apart from the moral case made out against insider trading, the very, very practical cases that it unnecessarily beats the image of quite good, very respected, it has potential to beat the image of very respected companies. It doesn't set a very good example, before the rest of the world as to how the Indian securities market is working. So out of all these practical considerations, all companies need to inculcate the zero tolerance policy. Look at the costs and benefits. I'm putting in this picture, which I hope many of you have read George Orwell's 1984, which talks about totalitarian state. So here there's this thing that Big Brother is watching you, and here Big Brother is not SEBI, let me assure you. It's not as if SEBI is watching the market. SEBI is doing this job in watching the market. This is my wish list, that a company has become Big Brother in watching over their employees, not in spying upon them as well, but watching for any unusual acts on their part, anything that will point to the possibility of insider trading. It never hurts to err a little on the side of caution in a alleged crime of this sort. So apart from this change in the way of thinking itself, we have provided various mechanisms in the insider trading regulation, prohibition of insider trading regulations. So we have the code of conduct, we have the code of fair disclosure. Then somebody is going to take a session on this structured digital database. That maintaining of a robust SDD is very much in the interest of the company. The next is sharing information to enable complete system-driven disclosures. You will admit that SEBI doesn't only wield the whip. It has also made things relatively easy for the industry through the system-driven disclosures. All that companies need to do, they need to provide the correct list of DPs, the designated DPs to the depository with the PAN and all the other details with pledge, etc., that needs to be given. And then you don't need to do much, because the circular already says that if you have fulfilled the requirements of a circular, then your physical disclosures are no longer mandatory. So SEBI also tries to make things easy. Ease of doing business is always on SEBI's radar. So I'm telling you both. We are trying to give you ease of business, but at the same time, the industry needs to cooperate with us and work together for preventing this menace. And again, Mr. Pawan also mentioned it. The way is basically in a gray area like insider trading, it never hurts to err on the side of caution. If you feel that there's some element of doubt, it is always better to tag it as a suspicious transaction. It is always better to tag one extra DP. Because when in doubt, disclose should always be the byword or keyword. I know it's easier said than done. Big companies, I have no doubt Ms. Savitri will tell me that in a company of the size of Reliance with so many transactions, so many people, it may be easier said than done. But as I point out the flip side, the reputational risk for any company, any company including Reliance, is quite huge. So this effort is a worthwhile effort. It needs to be taken. So this is one. I hope I'm not sounding too preachy. That's why I pointed out the practical aspect of it. And I've also pointed out what SEBI is doing on its part. So SEBI is always eager to, it's not ready, it's eager to promote ease of doing business. So if the industry comes to SEBI and says, please enable this also to enable ease of doing business, we'll lend you a willing ear. But again, you need to do all these things properly in your own interest, in your enlightened self-interest, not because the regulator is saying so. Okay. I think that should be all. This is the normal disclaimer that the views expressed on the speaker should not be constituted as the official view of SEBI. But the message about the seriousness of insider trading is very well the official message of SEBI that I can vouch for. Thank you so much.
Okay, thank you, Ken. Thank you, Kranti. Very nicely presented and very nicely said to the corporate world that how far SEBI has reached and how they are seeing from the lens, so nobody can be escaped. Whatever you are discussing as an insider, and SEBI can collect all the information. They have all powers. So let's discuss further. Definitely what Kranti has said, it's a eye-opening for the industry that SEBI is not only seeing the law, but they are just going what you are doing as a not a big brother, but is the big observer and with the minute lens. And I know I have read SEBI's various order recently on the insider trading, the way they have connected people, the way they have identified people. In recent one case where there was an insider, they had no relation, but SEBI has came out with the relation that they were the friends when they were studying together, and they identified and they are friends on the Facebook. So all these things we can understand how far, how deeply, and how the new age technology, by using new age technology, SEBI is doing this. This delta things which Kranti has showed, it is also indication that somebody is saying, I am doing this trade, but the pattern is important when SEBI is taking action. So thank you very much, Kranti. And definitely people are asking so many questions that we will discuss. Now over to Ravi. Ravi, you are aware that there are 7 or 8 recent cases set and Supreme Court has given judgment. Yes. And they have given the dimension to the interpretation of insider law.
Yes.
So I just want to ask you, please explain, these are the important case. So better you give the crux of judicial pronouncement on which we are discussing. Over to you, Ravi.
Yes, but may I take a leave to start with a little philosophical background to this legislation, and then coming back quickly to the judicial pronouncement and the principles laid down there. Now, as we understand, it is a market. Securities market is a marketplace, and the participants, mostly the buyers and sellers, they interact for economic bargains. It's an economic bargain which is going on there. Therefore, when a person is privy to an information, and because we say it is an admitted position that this market is information driven. So when a person has access to an information which is not available to others, he is in a dominant position, or he is taking an unfair advantage if he's trying to, based on that information, if he's getting into the market, entering into such bargain on the basis of such information, then it's unfair advantage. And this unfair advantage, regulators all across the world, to preserve the sanctity of this market, they want to prohibit. So if we talk about insider law, there are 3 annuals or 3 philosophical beliefs on which the insider law stands. One is to create a level playing field. Second is to boost investors' confidence. And third is to maintain market efficiency, because it is assumed, as per data published in concept of strong form efficiency, that whatever information is disseminated is reflecting in the price of scripts. And private information should not be allowed to intermeddle with that. Now, although it is very a case in point to explain that it is easy to legislate and hard to enforce, is this insider law. It was first envisaged in USA back in 1934. But it took them 23 years, maybe even more. 23 years is the reported number to frame first case of insider after the law was framed. So therefore, it's a tough law to decipher as well as to enforce, because a lot of nuances are involved. Not only the literature of law, but literature of finance, business, and trade all come in play when you talk about insider trading laws. In a speech of September 1998, Melissa Robertson and Thomas Newkirk, these were the officers of Division of Enforcement from Securities Exchange Commission. They said that it's a very difficult task to enforce these regulations because what we have is circumstantial evidence in almost all the cases to deal with. And Ms. Sardesai from SEBI has told us that how the regulator tracks these insider trading violations at an early stage through surveillance, tips and complaints, technological tools, examination, interviews, witnessing, with obvious objectives of establishing materiality, identifying suspicious trades, identifying insiders.
Ravi, can you speak a little louder?
Yes. Am I audible now, sir?
Yeah.
Yes. So the obvious objectives of these insider trading investigations are to establish materiality, which is the key concept around which the entire insider law, at least in the Western world, runs. Here it is called UPSI, there it is called Material Non-Public Information, MNPI, what is UPSI in India. To identify the suspicious trades and then identify the insiders, establishing the possession, because this is the key word. The law, the proper approach towards this law is to track down the information if one has to, and the associated proceeds and funds. Because wherever this information flows, it marks all the recipients as insiders and fiduciaries and connected persons by applying either classical theory or the new age misappropriation theory. Now, after you establish possession, the regulator's job is to establish scienter. Scienter is an alteration in the state of mind as to the motive why one would engage in insider trading based on that unfair advantage. And then after the scienter is established, which can also be through the surrounding conduct, not necessarily with the process of beyond reasonable proof, but on the principles of preponderance of probabilities harmonized with the surrounding facts of a particular case. After all this is done, and as Ms. Sardesai pointed out, it's a laborious task. She also demonstrated through an example of Delta, which was used in Infosys 2 after Pranshu Bhutra, which was overturned by SAT. That on that aspect, I'll come later on while covering the judicial pronouncements and developments. But it is nonetheless a laborious task. And there, after doing this laborious task, one has to think what kind of measure is to be applied. And this is also one of the very contentious issue. Most of the time, the appellants or the defendants before SEBI and appellants before SAT in the matter of insider trading, or when they are charged with fraudulent and unfair trade practices, their usual argument is that whether it was warranted to take this particular measure in this particular case, when SEBI has a host of powers and levies available, sanctions available under Section 11 and the whole set of provisions under SEBI Act. Now, what are the usual type of insider cases across the world? The cases are set up by regulators globally against the corporate insiders who traded in the company's securities after learning of significant confidential developments. Insiders, friends and family, as well as other recipients of tips who traded securities after receiving such information. Employees of fiduciaries and intermediaries such as banking, brokers, law firms, accounting firms, as she pointed out, and these three categories which I just said, we see cases, a lot of cases have been done in India covering all these three aspects. The fourth, which is a unique one, is the government employees who obtained the inside information or that material non-public information or this unpublished price sensitive information because of their jobs or because of their position of authority. Now, Mr. Desai also mentioned about a case of 2022. This is a very recent case, although it belongs to the transaction of Pfizer and Medivation belongs to 2016. It is in January 2022 that the District Court of California, it dismissed the motion of defense moved by Matthew Panumat on the applying the principles of misappropriation theory and saying that it would be possible for Securities Exchange Commission of United States to make out a case of insider trading based on the economically linked companies concept. She has rightly pointed out very summarily that in that matter, Mr. Matthew was former director of Medivation, which was sought to be acquired by Pfizer. And as soon as this acquisition became certain and he received a mail from CEO for this acquisition, he immediately purchased shares of another company, which was competitor of Medivation, called Insight. The company's name was Insight. These two companies were mid-cap companies in oncology, biotechnology industry. And there are very few players in this industry. It's a kind of niche in which these two companies were operating. And therefore, the argument of SEC was that because Mr. Matthew knew that after acquisition of Medivation by such a large giant as Pfizer, other acquirers who could not succeed to acquire Medivation would go after Insight. And true to the assumptions, and I'm calling it assumptions under quote, because the whole basis of SEC to bring a case against Mr. Matthew is that because he knew that Medivation has been acquired for certainty by Pfizer and the acquirers would come after Insight, he bought Insight. But here there was no particular piece of information, a certain information with him. It was maybe all the circumstances pointed out that this is likely to happen. Still, there was a risk involved in this assumption. But still, SEC argued this, and the district court said, no, we would not allow the arguments led by counsels of Mr. Matthew that this is not falling under the letter of law of the Securities Regulation Act there or under the bylaws anywhere. And this is rather an extension of the principles of insider law, which would result in anomalous results. The district court said that based on the misappropriation theory, and because the information there could be, and this is the principle which has been evolved, they said that there could be information or pieces of information in the market which could impact more than one companies. Means a single piece of information impacting multiple listed entities. For example, if X and Y both are listed entities and X is a supplier of Y, a chief supplier. So therefore, if Y is performing good, reasonably, the business is good, Y. So therefore, because of this relationship of supplier and buyer, at the other side, the grass would be green. So one who's aware that supplies are good here would know that profits would be good there as well. So this is the kind of concept that has been applied in USA that economically linked companies can also be brought under the ambit of insider, and one owes fiduciary duties towards those companies where one does not hold any fiduciary position per se. Secondly, that there could exist pieces of information which may affect multiple companies.
Ravi, Kranti wants to say something. Kranti,
Yes.
you have some point on this subject?
Just a little, technical correction to what Mr. Ravi was saying. The FP order was not set aside by SAT to give it this. The debarment was stopped by SAT. However,
Yes.
the impounding, that is, they did not challenge the essential story. What they said was debarment is probably not required to be continued, is all that SAT said. I'm just
That's
setting the
correct.
record straight.
That's correct. Investigation was directed to be continued. It was not a complete overturn of order, but interim directions which were continuing were modified. In fact, they recorded that the confirmatory order of continuing the ban was not required. And that's on different principles. I would cover them. So this was about the novel concept of shadow trading, which is evolving. But here is something interesting. This comes from USA in 2022, but let us look at what happened in India in 2018 and 19, and how SEBI applied this somewhat a concept akin to shadow, not completely the concept of economically linked companies, but a concept of collateral impact. In the case of 63 Moons Technologies, which is of 2018, it was argued by SEBI that issuance of a regulatory notice to National Spot Exchange Limited, which was a subsidiary of Financial Technologies India Limited, and the concomitant trading in the shares of FTL would bring a case of insider trading. This was vehemently opposed by the defendants, saying that there is no law, there is no basis when it can be argued that impact on a group company or maybe a holding company or a subsidiary would have an impact here. This was disregarded, and it's a very detailed order. It's one of the celebrated cases which is off-quoted. And then it was upheld by SEBI that the definition of expression price-sensitive information would include such kind of a trading, and it prohibits such kind of trading because it uses the word indirectly as well. Thereafter, in 2019, again, concerning FTIL, similar situation where a show cause was received in respect of Multi-Commodity Exchange of India Limited. A similar position was again upheld. Now, it would be interesting going forward to see that how far the ambit of and reach of insider law would go, considering these novel developments on the legal side. Thereafter, in the cases of insider, in cases which are charged under prohibition of fraudulent and unfair trade practices regulations, because it was recognized in one of the matters which went up till Supreme Court, Kishore R. Ajmera, which was a case of front running. The Supreme Court said that it would not be possible for the securities regulator to get hold of a clinching evidence or to catch someone red-handed in the securities market while they are manipulating a stock. So therefore, what we should do, should we leave the regulator toothless? They said no. And they pronounced this principle of, it was not the first time pronouncement. Of course, the principle existed in the jurisprudence, but it was applied and extended to the securities law with more force. We have decisions of past wherein SEBI have investigated in a lot of matters based on the preponderance of probabilities and harmonization of facts. But what seems to be the current judicial trend after the case of Balram Garg versus SEBI commonly known as PC Jewelers case, came out, is that this preponderance of probability cannot dispense the harmonization of facts and circumstances with the analogies that are drawn applying the principles of preponderance, meaning thereby that a call in itself is not an evidence, nor multiple calls like that could tell you that whether this is a case fit for insider trading or not. What really matters is that the investigation must bring out certain admitted positions or the quality of evidence by which it can be ensured that the rigors of this very stringent law, it's a peremptory law, and the rigors of this very stringent law, which denudes someone not only financially, but also on the reputational side, so that these rigors are not applied to innocent individuals or investors in the market. So therefore, this safeguard has been laid down. Now, if we look towards West, we would find that detailed procedure of investigations are framed, and we have also somewhat adopted from there and built our own, considering the peculiar situation of Indian landscape. But the quality of investigations is reflecting in the success of conviction or success of the cases brought about the regulators. If one compares in the regime of insider trading only, the success rate of Regulator of United States in contradistinct it with SEBI's, one would find that the investigation process, perhaps, coupled with the powers that SEC enjoys, because they have got powers of wiretapping as well. And this is how the famous Galleons case of Mr. Ajit Gupta and Rajaratnam was busted by the regulator. So therefore, the investigation, the way we investigate, the way we lead evidence is very important, apart from the law that we have legislated. Now, there is a whole set of information available from SEC. One of the senior attorney from Division of Enforcement of SEC, the Hilton Foster, has written a paper laying down what are the prerequisites, what are the essentials of an investigation, how we conduct it. And in that paper, he discloses something very interesting. He says that in insider, because we are faced with such dearth of evidence, direct and cogent evidence, where we find written that, oh yes, this man has done the insider trading for this reason, or this is the network, because this has all to be found out from the laborious task they perform. But he says one very interesting thing. He says that the false denials or the false statements to the question posed by authorities or the regulators, they become very strong evidence. Because if a question is posed to a person who's being investigated by SEBI, and that the person gives a denial which is exculpatory in nature, he feigns a defense which found or makes a statement which was exculpatory but found to be false, this can be held against him. In the recent case of Balram Garg versus SEBI, it was held that there is no reverse burden of proof in insider. It is for SEBI to investigate and bring and consider the facts in their proper perspective, and then use the principles of preponderance of probabilities to support the same. The 2019 judgment, it's an order because it's from Ontario's Securities Commission in the matter of Donna Hutchinson. makes out a compelling case. It also supports what Supreme Court has said in Balram Garg versus SEBI. They say that circumstantial evidence can be used to fill the evidentiary gap, but it cannot be used to supply the entire arsenal of evidence against a person for bringing out serious charges of insider trading. It has to be supported by something which is material and on which the analogies can be based. And to simply put, the courts are moving in the direction that when serious charges of insider trading or fraud are posed on a person, then apart from only analogies that are deduced from the facts and which does not in any conclusive way show that only this was possible and nothing else could have been possible, these could not be replaced for evidence even by applying the preponderance of probabilities, the theory of preponderance. So in a nutshell, they say that the combined weight of evidence has to be there, and the analogies must be logically and reasonably drawn out of the facts and evidences. In PC Jewelers case, although it is a common knowledge by now because this case was being discussed all across, that the chairman managing director, the allegation was the chairman managing director tipped off the information to the relatives, and this is how the insider trading was done. Two important facts which Supreme Court points out were not considered were that there was an estrangement by way of family separation. Although the parties continued to live under the same premise, there was an estrangement, difference of hearts at least. And on this aspect, amongst others, Supreme Court rendered its judgment. And probably it was if it could be said, the Supreme Court found that the evidence was lacking in the matter of PC Jeweler, and therefore they exonerate. Now, next matter, immediately after, let's go a little early in this judgment, which is of Pranshu Bhutra, also known as Infosys 1. In this matter, interim directions were passed, the usual interim directions where a person is debarred from market, can't access the market. But after the ex parte interim order, because it is also an established position that these ex parte interim orders are in the nature of SCN, and what the measures taken ex parte are not any punitive measures, but only remedial and corrective measures. And one can also reply to these orders, ex parte interim orders passed under 1111B. So after that order was passed, the representation was filed, and in the representation, certain set of defenses were taken. SEBI passed the confirmatory order, reiterating the decisions, modifying the directions that were taken, and appeal was preferred to SAT. In SAT, and before I comment on the SAT's order, let me tell this in all fairness. In the end of this order, SAT has categorically expressed that our observation would not bias either of the parties, and investigation would be carried out by SEBI, because they did not want to deter the investigation or stop the regulator from looking deeper into what happened in Infosys 1. But important is that while reasoning, SAT did quote an important aspect of this law, which has recently developed. It's structured digital database. In one of the paras of this order, SAT says that Bhutra's name was not included in the structured digital database. And therefore, it can not be assumed that he was per se privy to that information. Now, this was prior to PC Jewelers case, and this comes from SAT. Bhutra's order is a reasonably sized order, and it lays down and it runs across various principles of law, touches on various aspects of facts of that particular matter. It's a good read. After that comes the PC Jewelers order, and thereafter is cases of the confirmatory orders of Lux, and NIIT. Now in Lux, Mr. Desai has told that chain of connections were drawn based on the factual information, the telecommunications. I happen to be counsel for one of the parties involved. Therefore, I would not be commenting on this matter because since this is ongoing. But in confirmatory order in this matter, the directions were modified. Probably that was the impact of Pranshu Bhutra. Now, thereafter, NIIT orders came a few days ago, in which SEBI, and this is peculiar, SEBI has found that there was lack of evidence against one of the parties who was earlier charged with the insider trading allegations. Now, this is certainly a development which invigorates confidence that it is not that whatever case SEBI picks up, it finds people guilty of insider. It gives a message that after investigating something which might have appeared very suspicious in the beginning, after thorough and due investigation, it can have a logical and a plausible reason, which is not illegitimate. And therefore, each and every case is not supposed to be punished. So in NIIT, on the specific finding of lack of evidence and lack of involvement, person was discharged with the allegations of insider. Lastly, there is this matter of SEC versus Clark. And this is again from the Western jurisdiction. I bring attention toward this matter to round up and emphasize on the need of having a very strong investigative mechanism as well as ecosystem, including the resources that are required for investigation and the powers which the regulator must have, which has got such huge responsibility of administering this law, which goes against the very nature of human, that is greed, an inherent nature if one goes by the mythologies. So this is in SEC versus Clark, the motion or the case of SEC was dismissed because of lack of evidence. And in the order, it was observed that the evidence is still required in insider trading charges merely because there are communications, there exists to be some connection between the parties does not suffice the charges of insider trading. It is not an evidence of insider trading. What is important is possession, materiality of information, suspicion, which can be carved out of the holistic facts and circumstances and their harmonization with each other, and their reasons, which are proffered by the parties, the defendants who the regulator investigate. Thereafter, the scienter, and this could be curled out from the witnessing, which is a very crucial part, and probably we would see in the coming times that like SEC, we would also start the process of witnessing. We have the process of summons. SEBI does send summons for calling information from persons on who they investigate. But this witnessing, these personal interviews where statements are recorded, where people are asked to take a definite position on the questions posed by regulator, these may help the regulator in cracking down on insider trading like never before. So therefore, these are the elements, or I would say some of the essentials, because this is such a vast topic and ever dynamic that one cannot say with clock-like precision that only these principles would apply and other would not. So therefore, these are the indicative essential measures which must be adopted, which must be followed if we have to deter the meanness of insider trading, which widely acknowledged is prevalent and pervading across the Indian securities market. And that is it. I would contribute further when the questions are taken up.
Okay, thank you, Ravi. Thank you very much. You have covered all the cases in the Genesis. We will take comments of Kranti when the question answer session will start. Now, two very learned professionals are with us, and they are part of the very big group. So we just want to understand the insider law from their perspective. So Savitri, I will start with you, then I'll go to the Pankaj. What is your overall thought about this insider law? How things can be managed? Because you people are icon for others. So the SEBI is saying zero tolerance. Judicial pronouncement is also saying that they are not refusing totally. They are saying you can reduce this harsh penalty, or you can do this, but they are accepting and sustaining the order. So under these circumstances, we are finding that every day something is happening. Every time something is happening, and every professional is confused whether this information I have to give to the market or not, how to handle this, what are the things. So Savitri, your view or overall, and you were part of the earlier programs also, and you have contributed a lot, and you have discussed each and every aspect which you have faced in your day-to-day life by handling this. So we want to understand from your side.
Yeah. Thank you very much, Pawan. First of all, this has been a wonderful program, and I thoroughly enjoyed the two sessions for this question answer session. So coming back to the question, Pawan, in terms of insider trading, of course, Kranti did mention that he's not meaning to scare, but I must mention that all corporates and all persons associated with corporates are certainly very scared of insider trading regulations. But let me talk in terms of measures that one can put in place. I think the whole process starts with creating awareness, and creating awareness amongst people in the organization across different functions. And more importantly, I would say that, and I've said this earlier also, with respect to relatives, it is necessary to ensure that the immediate relatives are also sensitized to the requirements of insider trading regulations. The other point that I would like to mention is with respect to portfolio management schemes. Very often what happens is junior level employees, maybe in accounts or maybe in other departments, may not understand the distinction between portfolio management scheme and mutual funds or SIPs. I've had several people come and ask me if PMS is permitted because mutual funds are permitted, or if SIPs could be subscribed to by them. And I've often told them that SIPs are dangerous because, you know, if it is during normal times, it's fine. But if there is some price sensitive information which the person is working on, I mean, this was very often asked in my earlier organization, I must clarify. And more importantly, with respect to PMS, typically in India, we are used to signing where there is a cross mark, not reading all the papers. So when you're investing, you need to understand that if it is a portfolio management scheme, the shares will get credited to your account from the pool account. And if the credit happens during the window closure period, the violation has been committed by the designated person concerned. And this cannot really be waived by the compliance officer. In fact, portfolio management schemes, even if you have asked them to put the scripts of the company in the gray list, very often when the relationship manager changes, there are issues which crop up. Having said that, how do you address it from a company's perspective? I would say first, as I said, awareness is the key. Second is, you keep ensuring that these awareness modules are repeated at periodic intervals, and every employee is compulsorily required to go through this. Having said that, is this 100% foolproof? Human behavior is something which no one can very confidently confirm and say that nothing will ever happen. Sometimes it happens by mistake, and sometimes it's one which is beyond the control. Like say, for example, if you have given an instruction to the broker to buy or to sell, and you have not taken care to tell the broker that there is a window closure and that he cannot do it towards the end of the quarter, unfortunately, the employee then bears the brunt of it. So there are these kind of harmless cases also where there is no intention. I would say that normally in companies, most people are vigilant now. And especially in large organizations, they are fairly vigilant. Over to you, Pawan. And Pankaj, you may add further.
Okay, thank you, Savitri. You have touched very important point, and I think in the question answer session we'll take your input. Pankaj, over to you.
Thanks, Savitri, for sharing your valuable insights, and thanks, Pawan, for having me over. Let me start with ground zero. Before we start interpreting any law or talk about the organization's policies and procedures, let's see what is the intent of law. The best place to look at the intent of law is the preamble of law. So let's see what the preamble of law says in the case of Companies Act. It broadly says to regulate the functioning of companies. The famous preamble would say to regulate foreign exchange. Whereas under the PIT regulations, the preamble says to prohibit insider trading. This is a very significant shift in the preamble of other laws. So this is not a beneficial piece of legislation. This is not a prescriptive legislation. This is restrictive and prohibitive legislation. And the learned speaker from SEBI also clarified that it's a zero tolerance approach which the regulator expects, which aligns with the preamble of the law. This means that the corporates will have to have a very conservative, or I should say a robust approach to deal with the intent of law. And I'll just highlight 3 points which I feel are very relevant in terms of that approach. One would be to keep the bar of approval very low, threshold of approval very low. And let me explain this by an example. If the pre-clearance threshold is 500 shares, which means a trade of 400 shares will not come for approval before the compliance officer. Now, what happens if this 400 shares is also a case of contra trade? In that case, the pre-clearance limit of 500 will not ensure compliance with the letter and spirit of law. So to sum it, the threshold for approval, the bar should be very low, which means all transactions should come for approval before the compliance officer. Number 2 would be to err on the side of caution, to look before you leap. SEBI has published very good guidance in the form of FAQs, in the form of informal guidance, and most importantly, wide exemptions in Regulation 4. In Regulation 4, when the law was enacted in 2015 and later in 18, there were very limited exemptions for promoters, inter se, in off-market trade. That list has been expanded to cover corporate transactions, buyback of shares, preferential allotments of shares, and all legitimate transactions which are governed by SEBI regulations have been rightly kept out of the ambit of insider trading regulations. Which means when you're doing a transaction, look at the exemptions, look at the guidance, and be very sure of what you're doing. If in doubt, then seek guidance. And third, as Savitri rightly said, awareness through sensitization sessions, awareness through reinforcement of learnings, and also relying on automation more and more. That creates credibility in your data, that makes job of everyone easier, and that reduces human effort and ensures a better level of compliance. Back to you, Pawan, and your team, and I'll be happy to take any relevant questions.
Thank you very much. Thank you, Pankaj. Giving this the word, the preamble and the word of prohibition, that is rightly pointed out. Now, as you have seen, what the regulator has said, what the practitioner has said, what the two corporate giants has said. Now, if you remember that insider trading law talks about the maintaining of digital database, that is structure SDD. So what is this SDD? Because this is also very important. So I'll just request Mohini to tell the how this should be managed and what was the system. Then I'll take up the question answer.
Yeah. So good evening, everyone. So with respect to the SDD, so before to start that what the SDD and how it is to be maintained, first I want to give you a brief about that why this SDD thing has arisen. So I'm just sharing my screen. So with respect to the SDD's full form is structured digital database. That means whatever the database we are maintaining, it should be in some structured form. The format, definitely the structure has been defined by the SEBI, and it is in a digital mode. So why this SDD now? So this SDD idea was generated in 2018. And it was introduced in the regulations when the new amendment came in 2018. And to make this provisions applicability, so the applicability of the provisions was started from approximately in 2019, they need to start. And definitely these this SDD also to be, it started from the 2019. So in the structured digital database, the requirement is not restricted only up to the listed companies. So this SDD requirement, wherein the SDD to be maintained, is extended to the intermediaries as well. So here this structured digital database reporting came in 2018 circular. So now the responsibility to maintain this SDD is on the board of directors and the heads of the organization. That means because it's a part of an internal control systems, where now this, because the SEBI also expects from all the listed companies and even including the fiduciaries, that means who the persons, the intermediaries, the either it be an auditor, either it be a merchant banker or any practicing company secretaries, legal advisors, legal firms, who are dealing with the sensitive information of the listed clients, all should maintain this SDD. So the responsibility to maintain this SDD is on the head of the organization, because as per the law, they are responsible for managing their internal control systems. Now, with respect to when we are talking about it in a digital mode, and we are talking about it that it should be maintained by all entities, so where it should be maintained in a digital mode. So here they have made a clarification very well in the by the SEBI that it should be on the in-house server of the company, and it should not be outsourced. So that means there are before this clarification, the companies are maintaining this database in some cloud model provided by various other service providers. But after the circular in 2021, they have very clearly mentioned out that it should not be outsourced and it should be maintained internally. And with respect to the outsourcing, even they have made a further clarification that it should not be maintained on third-party vendors' cloud. Like even they have mentioned that if you have an Amazon, Google, or any other cloud server, there it should not be. So that means for this to maintain, you should have an internal server ready with you. Even a Windows system can be used for maintaining this, but the access of this database should not go outside the limits and the premises of the company. The next important thing is that the basic requirement of the law is definitely a time stamping. Why the time stamping is being asked in this maintaining when the structured digital database we discuss on. So here the time stamping is with respect to that when the information is being shared, because we are maintaining it for the UPSI. So when we are maintaining it for the sharing of the UPSI, so that means when the sharing of information is started, this is very important point, and when the person with whom who is a recipient either, so when he has received this information. So this is a very important first point, that from where that the person comes in the possession of that UPSI. So this is from where the things have been started. So this is the reason why they want it to be a time stamping thing. And audit trail is definitely so that nobody can go and change those things to ensure, and you should ensure that there should not be an unauthorized access to anyone, and it should be in a non-tempered manner. So what exactly in the SDD need to be maintained by the companies? The important, as I earlier covered that it is with respect to the information sharing. So the information is being channelized from one recipient, from sender to the recipient. So the information of the recipient is also required, and information of the sender is also required. So the PAN number, name is required of the sender and as well as of the receiver. And the second is the date when it has been shared, time from when it has been started sharing, and importantly is the nature of the UPSI shared, and the mode of sharing and the purpose of sharing of UPSI. So these are the things which we need to maintain in the structured digital database of any company. So for meeting this requirement of this law, corporate professionals has designed an internally an in-house through an in-house technical team of ours, this Analysis software, wherein this application we can maintain the entire this SDD process. So how it is to be maintained, I show you through my a live through the tool. So I'm just opening that tool as well. Just hold on, I'm just sharing my screen. Yes. So this is our tool. It's a web-based application, definitely. So one can host this application at their server, in-house server. And we are presently have the clients, more than 150 clients, wherein this application is running successfully. So now I show you that how it is to be maintained with respect to this SDD part. So I start because, okay. So to start with, first is whose responsibility is to maintain this data. So the person who is dealing with the insider, in the organization is generally the persons who have been designated as a designated person in the company. So these designated persons' first responsibility comes here that he should be responsible for getting the information which is required to be stored under the SDD. And there are few other requirements under the law as well, which they need to share with the insider. So this this responsibility, we think that it should be of only the DP. So we have given the right in the DP to start with to have this information and to enter the insider details first. So how it is to be done? Just what all information we will be asking on the insider front first. So we are so when we ask about that, what all the information of the, because recipient is generally the insider. So when we talk about the insider, so we will be collecting here is that first you need to select that what type of insider you are sharing this information. He is an auditor, consultant, employee, legal advisor, lenders. So first you need to select that insider type, and these insider type have been mentioned in the law itself. Then it comes to the PAN of the organization. That means if it's a kind of a corporate entity with whom you are dealing with, so you have to write the PAN number of those organizations you have to collect. Then the NDA need to be signed with those insiders, informing them that they are in receipt of the UPSI and they should not share this information for any other purpose. So that NDA you can upload here. Then you have to select that for which company of yours this consultant belongs to, whether is working for, because in your being a listed company, you can cover your consultants or legal advisors of the subsidiaries as well. So this is the so company you need to select. the appointment date of that particular insider, because from there we assume that the sharing of the information has been started. The name of the organization is which kind of organization it is, then where the address of that organization, the contact details of those organization, and the email ID, the phone number basically. And then because in the organization is not working per se through itself, they're working through various other employees of theirs. So we require the information of that dealing person as well. So with respect to the dealing person, what we are asking is that we are asking for the email ID, name of that person, designation, then the PAN number of that person as well, the nationality of that person. If nationality is not Indian, then definitely you can have other identifier as well, the phone number, etc. So this is the information of the person with whom you are dealing with respect to the insider. So once this information is collected, so we are done with the contact detail, PAN number of the insider. Now, with respect to the designated person, because he is the sender of the information, so here we can ask the information of this designated person here, that which company our DP is, where he is located, what's the name, what appointment date is per se, nationality, and definitely as per law, you're also collecting the information of educational and past employment. And if he is not an Indian citizen, then definitely other unique identifier, official email ID, alternate email ID, and any NDA which you are signing with those insiders. So this is how the PAN of, so the basic information of both the sender and receiver we have collected. Now to start with, so first is the how the purpose of this SDD now to be started. So first is that the admin or any other designated person first have to create a project in the system. So what the project, how the project will be created, because project creation will help us to see that who all the people are involved in that project. For example, there is a project name, project special. So we just mention that name of that project, the project starting from which date, the purpose of creating that project, because ultimately we need to have this information in hand. Then then we need to allocate the designated person or insider in this project. So we can have the designated persons within this tool. So we can search the designated person. So for example, any designated person can be selected. Similar in the manner we have the insiders in the organization, and we can select the insiders as well here. So here we can create the projects and the person. Now I move on to the, so once this project has been created, this project now started for and available for view and for making an entry with the with the designated persons. So now what the designated persons will do, I just move on to the designated person's ID and show you that how the designated person will be making those entries, and the cycle of SDD get completed. So 3, 4, 7, 5, 6, 8.
Queenie, I think you give the broader aspect, don't go inside. I think that you can share with others. I have a various question answer. Okay.
Sure, sir. Sure, sir. So I am just only showing the last that how the entry will be done. So it's only the it's only the last part. So it's a designated person's login, wherein the designated persons can simply
Sorry, ready second. मेरा iPad उसमें डालना है बैग में.
So the designated person has to simply go and they have to simply select that with whom they are sharing this information, the date, the time, and if they are involved in any project, and the email ID already, and the time, and the particular of information shared, and the mode. So in this manner, the system captures all this information, and whenever any requirement of UPCI sharing is required, the admin can fetch this information and can provide to the sector. Yeah.
Yes.
So over to you, sir. So this is with respect.
Thank you, Moni. Thank you very much. So now everybody has given their presentation. Now time to question answer, and I have received so many questions. So I will just one by one ask questions which we have received. So my first question to the regulator, the question which has come, which I will ask, how were the calls traced during the trading which happened in the Lux insider trading case? Kranti.
Yeah, like Ravi, he is also in anomalous situations because he represents one of the defendants. And I am in the anomalous situation because I may or may not have dealt with the case, but I'm certainly in the seat of an accuser. But I'll give this general thing, whether in Lux or whether in any other case, SEBI has the powers to call for call data records. The call data records will not give the call transcripts or the call recordings. However, it will tell us who spoke to whom at what point of time. So that is where we need to join the dots and see whether the calls were in proximity to UPSI or any other suspicious circumstances, etc., and complete the story. So these are my 2 bits on the call data records of the universe.
Okay. Savitri, we are a listed entity having code of conduct under PIT regulation. We also have the debt listed subsidiary and have extended the parent entity's code of conduct to the subsidiary company's employee. Hope there is no need to have a separate code of conduct for the debt listed subsidiary.
So Pawan, under Regulation 9, Sub-Regulation 2, the responsibility is on the board of directors of the listed company. So therefore, the board of directors need to adopt the code of conduct. Now, here the board can adopt the code which the parent company has, because Schedule B, which has the minimum requirements which are required to be covered in the code, that in any case the parent company's code will anyways have. If the same thing is okay with the subsidiary, if there are no additional points and the subsidiary is okay even if there are additional points, it's fine. But it is necessary for the board to pass a resolution adopting the code, and post which they can take that code as their code.
Okay. Pankaj, if any designated person purchase sale only 1 share, then what would be the consequences in this regard? Should we only warn him or for the first time or levy any penalty? Though it's a question of regulator, but I'm asking you.
There are 2 aspects here. One is the model code of conduct, which talks about any contravention. So it does not lay down a threshold of contravention. So any contravention has to be reported. It doesn't also talk about penalty. So I mean, it is depends on the organization. But if it is a 1 share, very inadvertent, still it has to be reported. But if it is first time trade, then many organizations follow a policy of reprimanding and sending a warning letter. So first, in terms of reporting, any violation has to be reported. And second, penalty, that is depends on the gravity of the offense. If it is the first time and 1 share, as you mentioned, inadvertent, then obviously it's not a case of insider trading. That's very clear, because nobody will trade 1 share for the purpose of insider trading.
I would just like to add 2 further points, if I may. One is, of course, just as Pankaj said, it has to be reported, even if it is 1 share. 2 specific points need to be considered. Is this the first time offense? If it has happened more than once, then yes, penalty should be imposed. If it's just the first time with just 1 share, I fully agree with Pankaj that it will only be a warning. However, one more thing which needs to be seen is whether there was any gain which was made. Say, for example, if it was a case of sale, then one would be able to very clearly see whether there was a gain at all or not. What was the price when the trading window opened, and what was the price at which he had sold can be seen, and the difference, if at all, assuming that he has sold at a higher price, then there is no difference. But if he has sold at a lower price, then if he has sold at a higher price, then in that case he's actually made a profit. If he has sold at a lower price, he's not really made any profit on that. He would have sold it, at a slightly higher price after the window closure had got completed. So in this case, if he has made any unintended gain, the same should be deposited to the IPEF. And if it is a case of purchase, you would then see a notional gain which is made and make over to the IPEF.
Okay. Okay. Kranti, you want to say add
Just in a
anything?
lighter way, Pawan, I'm glad you did not ask me this question, because anyway, the regulators are many times accused of being too prescriptive and too professorial. So that is one there where I'd like to plead innocent.
Okay. 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 Okay.
But I hope you're happy with our answers.
Okay, Ravi. Whether any criminal action can be taken in case of insider trading?
Yes, certainly.
Okay, Moini. Okay. Do you require to maintain a structured database even when EPSI is shared with the company?
Yes, even within the company, yes.
Okay. Savitri, for proposed to be listed company, from when does the PIT regulation become applicable? From the date of filing of DRHP, RHP, or prospectus?
I would take a conservative view, and I would say that it is from the date of filing of the DRHP, because that's the stage where you are showing that you intend to get listed.
Okay. Okay. Kranti, system-driven disclosure does not have an option to map the PAN of immediate relative of designated person. Hence, transaction entered into by them remain untracked by the SDD system. This may lead to non-compliances under the PIT regulation. What is your take on this?
My take on this is that SDD, system-driven disclosures, has been an evolving process. Earlier, we had promoters and directors. Then we added the promoter group and designated persons. So as of now, so this immediate relatives are not covered under the system-driven disclosures. That does not mean that they don't have to disclose. Then they can disclose by the original way they did, so physical to the company. So just because they are not covered in the system-driven disclosures doesn't necessarily, act as a hindrance. As of now, they can continue to do the way they have been doing, and in due course they will be covered. I take it.
Okay. This is Pankaj. This question I'm posing to both the Pankaj and Savitri. In case of unintentional case of one-way sale purchase of shares of small value, say rupees 5,000 during the trading window closure, how do companies handle such cases? And you must be facing this type of problem day and night by your employees to whom you have given ESOP for shares.
Savitri, would you go first, and because you covered some part in your earlier answer, and then I will come back.
Sure. Okay. So if the value is less than 5,000, it's very similar to the question of one share where there is a violation. So there are two parts to this. One, trading during trading window closure is one which cannot be excused, and it is certainly a violation of the code and requires information to be given to the stock exchange. In terms of how exactly does one handle, if it is a first-time offender and there has been no unintended gain which has been made, then it will be a fit case for just a warning. But if it is one where there's been a gain, ensure that that amount is put into the IPEF and ensure that it is the person is given a warning if it is first time. But if it is a repeated one, you definitely would also have a penalty being imposed on the person concerned. Over to you, Pankaj.
Yeah, so I think there are two aspects to it, and I'll just the first question that you raised, Pawan, on one share. So one is reporting of the transaction, which is a separate requirement, and if a transaction has happened and not in accordance with the code, it's a violation and it has to be reported. Now, whether it is an case of insider trading or not, you have to look at the defenses under Regulation 4, and is that transaction eligible to claim those defenses. So reporting, non-reporting in itself is another requirement. For example, if a transaction is reported, it could still be a case of insider trading because while it is reported, it is not a fair transaction. On this particular question, I would say if it's a small amount under window closure, then in window closure, there is a very unambiguous contravention of the code of conduct for which there is no exemption. Penalty again could depend on the nature of offense, the frequency, if it's the first time, because a small value can happen through because of multiple reasons. One could be this PMS, which some of the other panelists also mentioned PMS through other means where it is inadvertent. So if it is a case of first time, if it is a case of inadvertent, if it is a case of very small amount, then the penalty could be as per the policy of the company, which could be warning in the first case, but otherwise reporting stands.
Sir, you are mute.
Okay. Kranti, this question is for you. Should debenture be regulated only with regard to sale of debenture rather than purchase of debentures? What is your view? You have to unmute yourself. Yeah.
Sale of debentures is certainly, during UPSI period, there's certainly this a ground of suspicion. However, if you see the language of the regulations, it prohibits, as of now, buying, selling, and dealing. So it does not make any distinction between purchase or sale or any other, dealing. So as of now, it stands. Purchase and sale are both covered. If you want to make a case for removing purchase from the regulation as it stands, that's a separate story.
Okay.
Pawan, I would want to add on that just one small point on that point. Even if it is under window closure, SEBI has recently provided some exemptions there as well. So if it is between two people having the same information, block trade, then trading window also doesn't apply in some cases, including rights issue and all that. One has to see that. Therefore, the exemption list has been separately elaborated. So trading window closure, to start with, yes, it is. It's not on the right side of the law, but one has to see whether it is under those specific requirements.
Okay, Ravi, whether provision up to regulation 4 dealing with burden of proof, it is inclusive or exclusive?
Well, it is inclusive, but the indicators, the prescriptions are only indicative. It has far-reaching ambit, but the burden of proof is not reverse unless until the prima facie obligation of accusation, leveling an accusation with certainty is discharged, the burden of proof is not reversed. So therefore, it is for SEBI or the accuser to first levy it or to charge with certainty.
I'd like to add to that, if I may. Yeah, what Ravi says is certainly true, that for the first accusation, the accuser has to make out a plausible story for the accusation. But even so, the BIT regulations have a particular provision in this burden of proof. So there's slightly higher, responsibility is placed on connected persons to prove themselves innocent. If I might read out, in case of connected persons, the onus of establishing that they were not in possession of UPSI lies with on such connected persons, and in other case, the onus would be on the board. So without gainsaying the logical assumption that the story has to be plausible, there's still a higher burden of proof on connected persons and others who are in possession of UPSI to prove their innocence.
Okay. Mohini, if a company manages SDD in Excel with the time stamp, is it sufficient compliance of law?
No, because Excel is not. Excel is we can't prove that Excel is a non-tempered. You can change anytime, go and change the Excel. So Excel is not the best way.
Okay. Savitri, whether the compliance officer is empowered to grant relaxation and waive penalty, recovery, disciplinary action under clause 412 of Schedule B for contravention of code of conduct as she has under clause 10 with respect to contra trade. Clause 4, subsection 2 provides the designated person, immediate relative shall not trade in security when the trading window is closed.
Right. So actually, when the trading window is closed, as per the code of conduct, any trade done during that period will be a violation, except of course the relaxations which have been granted to a small group of persons who are in possession of the UPSI, who are in the same group. But otherwise, any other person who does a trade during the trading window closure period is actually doing it in violation of the code. The compliance officer does not have any authority to relax any of the disciplinary provisions. Here, with respect to the disciplinary action, a good practice is for the audit committee to approve a standard set of disciplinary action which the company would adopt. And based on that, disciplinary action would be taken against the person concerned who has erred with respect to the code. So there is no power which has been granted to a compliance officer to relax anything. Let's say, for example, if it's a very innocent violation of a very small value, the disciplinary action itself would say a warning, in which case that's exactly what the compliance officer would ask, would communicate to this person concerned. And the compliance officer relax it? Answer is no. You're on mute, Pawan.
Okay. Kranti, what are the ways to do trading during trading window closure period for promoter group?
Now we are entering into controversial area. This trading plan that the regulations, that they give an open window to all the designated persons, promoters, directors, etc. It is especially for the designated persons, but it could be good. I mean, generally promoters are anyway classified as designated persons, directors also in a way serve as a designated persons. So they should ideally take the trading plan route. Now, I know that people, the perception of people is that this trading plan, this route is not so easy to follow. That's why sometimes I feel that if you are whatever genuine difficulties people face in implementing the trading plan, they could always come with suggestions as to how to improve the present mechanism. Is all I can say at this time.
Okay.
Actually, ma'am, trading plan is a mandatory to follow, and it is for the 1.5 year you have to give this prediction. So it's very difficult.
I know. That's in the beginning. I said that I'm entering into controversial territory here. But there is a way of, the question asked was whether there's a way of trading by promoters and directors this time. So the trading plan, to my mind, is a sound concept as a concept. Now, the contours of that concept, they can be debated. Whether this period is too long or too short, what is the ideal period? Why can't it be changed midway? These are all questions that follow the concept. So once we accept that a concept is sound and it is implementable, then ways to improve it can always follow.
Okay.
So,
okay. So Kranti, just tell me, suppose I have given a trading plan and my plan was to purchase a house and the decision is changed and I don't require money.
Pardon me?
Decision has changed because I wanted to buy a house. So that's why I have given a trading plan. Okay. But now my decision has changed. So even then I have to do trade.
Yes.
You're saying
as per the law.
You have
yes. Yes, you have to. Yeah. It is unchangeable. I mean, once you give it unchangeable.
I think. Yeah.
But then, speaking of the other side, finally, the restriction is primarily on trading in the securities of either the company you work in, where you're a DP, or other securities in which you are trading where you want the possession of UPSI. So the restriction is only with respect to trade in one company. So the analogy of a house where you can actually want to buy any house, here you're only restricted from trading in one company for very sound reasons. Let me put it this way.
Okay, now rapid round is starting because we have so many questions and time is less. So everybody has to quick and to the point. Okay, Savitri, what value to be written in form C for relative transaction in case of gift transaction? Market value or zero?
Market value.
Okay, Pankaj, is it mandatory to enter the detail of immediate relative in NSDL database?
No.
Any other person?
No, it is not. Currently, it is not required because the NSDL database does not require details of the relatives. I mean, the September 9, 2020 circular does not provide for relatives details to be given. So that's the which was also touched upon by Kranti in her presentation.
Okay. Mohini, does closure of window for quarterly result also require recording information SDD?
Yes, because it's a UPSI.
Okay. Ravi, does the company have to monitor the trade of connected person For example, a DP has resigned and exited the company. Do we have to monitor their trade for 6 months? I think any other practice, Savitri, Mohini, and
Sir, from my side, it's no.
okay.
Yeah.
It's on
So the person
responsibility is
becomes
on the person.
Yeah, so the designated person who quits the company becomes a elected person, and the responsibility is on that person.
Correct.
Okay. Okay. Who's responsible is to update the SDD regarding sharing of information by DP to which CS is not aware? Will CS be held responsible for non-updating the information?
No, the person who is sharing, the clear burden is on him to update this information in this DD.
To this end, there is an order of SEBI which
Yes.
recognizes this.
Okay. Pankaj, how a listed company ensure compliance of provision of SEBI or PIT by immediate relative of designated person if they buy shares of that listed company without informing to company or DP?
So there's a robust procedure stipulated in the regulations. They have to sensitize, seek information upfront, and seek declarations.
Okay. Okay. Mohini, if a structured digital database is monitored in the Word of Excel format, register, can it be? That answer is you have given. Okay. System-driven disclosure does not have the option to map the pen of immediate. I think this is also done.
Yes.
With respect to intermediaries, contra trade restricted to 6 months applicable for a designated person, even if he is not connected person of the listed entity in which he has traded. What should be done?
Yeah, sir, it's up to the code of conduct of all the intermediaries, and this contra trade restrictions, intermediary in their code of conduct have to maintain some kind of contra trade restrictions on that.
When violation of PIT regulation is discovered, by that time DP has separated from company and not contractable. How do companies report the same, and what steps should be taken?
Ravi, I think.
Yes. Therefore, even if the designated person has separated his relationship with the company, if the violation was pertains to a time when he was an employee and he was a designated person, the company must report it. And it's a different matter whether what effective directions company can pass for disgorgement of gains to IPL. That's a separate matter. But I think in these matters, companies should also frame that they before releasing employees to a designated person, they must ensure that there are no violations with respect.
Okay, Ravi, the same legal point. Any monetary sanction under the internal code of conduct levied applied to the DP, can it be technically called a penalty under SEBI Act?
No, every action which a board or the committee, the relevant committee takes, because that is the first line of defense, this 2015 regulation created after Justice Sodi's recommendation. So, but the penalties levied by company is not considered as penalty under SEBI Act. It is without prejudice to that. SEBI can take an action.
Kranti, any point in what Ravi has said?
Regarding the views he shared during this particular question?
This particular question.
This particular question is what he's saying is correct, that this action by the company, again, under their code, does not preclude SEBI from taking any action if it considers the issues serious enough for the next.
Okay. Kranti, what are the essential ingredients to allege insider trading?
I think Mr. Ravi already discussed it to some extent. I mean, of course, you need to have an insider. He needs to have traded during the UPSI period. These are the basic ingredients. There needs to be a plausible set of facts and circumstances that say that based on preponderance of probability, this guy has that insider trade. So we cannot hold the level of proof to be as in criminal law. I mean, any legal person, correct me if I'm wrong. We do not need to prove it beyond reasonable doubt, or we do not need to say that this is the only explanation, there cannot be any other explanation. That may be carrying things a bit too far. There has to be a plausible story. There has to be a proven insider. He has to have done trading. And that is what are the essential ingredients of insider trading. Beyond reasonable doubt cannot come into the picture.
Yeah, because I think the guidance is there in the note to Regulation 4, which very clearly says that if a trade has happened, then it is presumed to have happened with the knowledge of the information.
Okay. Okay. Pankaj, whether it is sufficient to prove insider trading if the DP has traded during the trading window closure period?
that I had covered in my earlier point as well, that if it is covered or allowed under some of the exemptions which are given to select group of people, then he is not guilty. Otherwise, you will start with the fact that it is not a permissible trade and see whether you fall under the exemptions.
Okay. Savitri, if an employee has purchased 100 shares on 1st February 22, second, and then again purchased 400 shares on 15th March 2022, when will be able to sell the shares purchased on 1st February 2022? Will it be after 1st August or 15th September?
15th September.
Any different view, Moini and
So,
okay.
sir, it's for the transaction. It's not for the shares. So it should be very clear.
Okay. Okay. Kranti, who has the onus of proof showing that the person is in possession of UPSI?
Again, we have more, I think, slightly covered in our earlier discussion, where you have proven that the person is a connected person. An insider is either a connected person or who has access to UPSI. So when we are saying that we have said that a person is connected person, it is coming under any category under 2(1)(d). In that case, the onus of proof is on the person to say that no, I was not in possession of UPSI when I traded. In any other, whether there's no tangible proof to show that he's a connected person, then the onus of proof is on the person making the accusation, that is the regulator. That is the position in law as per the PIP.
Okay. Pankaj, if an employee makes a buy transaction and then 2 consecutive sale transactions within 6 months, then it amount to 1 contra or 2 contra. If an employee makes 2 buy transactions and 2 sale, then it amount to 1 contra or 2 contra.
So one is a legal answer, which is contra trade is always with respect to the last trade. So if it's a buy transaction, then another sale transaction, then the next sale transaction will not be a contra trade because contra has to be the last transaction. But the facts could determine. So if it is 100 shares of buy and then 50 shares of sale, another 50 shares of next day, then SEBI may take a different view. But if you ask a technical view, then contra is always with regard to last trade.
Okay. Ravi, can frequently communication between the parties be adequate material to show communication of UPSI?
Very subjective, but yes, so far these are used to develop on the principles of probabilities. But yes, not entirely sufficient. If the other factors are saying otherwise, this is not. This might not be sufficient. But
in
it's
the last case, SEBI has done this.
Yes, not only in Luxor, a lot of cases. There are a host of cases.
Okay. Okay. So, Moini, Mr. A has having a UPSI and he is not sharing it to anyone. Do he need to make any entry in SDD?
No, he is not supposed to until and unless he shares it. But definitely the company should record that this person have some project or have some UPSI. But sharing is not required.
Savitri, if any DP has stated in the shares of company without pre-clearance, what is the procedure to be followed?
So without pre-clearance, was it during window trading period, window trading closure period, or otherwise? Let's say it is during a period when the window was open and pre-clearance was not taken. It will be a violation of the code and action will be taken accordingly. During trading window closure period, there is no question of giving pre-clearance because the para 6 of Model Code of Conduct very clearly says when the trading window is open. So when it is closed, the compliance officer has no authority to give any pre-clearance.
Okay. Kranti, a very interesting question has come from. Now, right issue is exempted from contra. Okay. Yeah. If I'm buying, suppose I have a 10,000 shares and I got a 5,000 right. So now I have 15,000. Okay. This 5,000 is once it is exempted, even window closer, it is exempted. Okay. Yeah. Now I want to sell. And the restriction on the sale is on tar 15,000. Is it correct interpretation?
I should think if rights issue is you earlier mentioned that the rights issue, the shares in the rights issue are exempted from contra trade. But you're saying if I'm already holding this 1,000 in the normal course and I've added 5,000 in the rights issue, that is the fact.
Yeah, that's right.
Correct. So the contractor obviously is exempted for the earlier holding that you have had, where there's no exemption provided.
What do you say, Pankaj? Is it
I think as per the regulations, what Kranti says is correct, and the FAQ, because if you read the FAQ, I mean, to be fair to the regulator, they cannot deal with every possible situation. So the FAQ talks about the trade. But if you look at it logically, if there is an exemption for right buyer, then that the fact of that exemption is negated by disallowing the sale of previous holding also. But then, because if the exemption is there for procurement, the exemption should also be there for selling the shares which were held prior to the rights issue. So otherwise, if you give the exemption, but it gets negated if the restriction on sale applies. So, but the regulation.
Okay. Last question, Kranti. Does PIT regulation apply to a private company whose business is investment in stock? Any other?
Being in India. Yeah, ma'am. Yeah, please.
No, you make your point. I'll speak later. Yeah.
So if it's an investment company and dealing with the information of the listed companies and being in fiduciary position, definitely the PIT is applicable.
Okay.
Precisely what I was going to say. The access to UPSI and the dealings with other companies are the key factors.
Okay, friends, now it's time to close this session. I will just tell, we received around 50 questions today, 13 before the program and 33 during the program. And we have tried to give all answer. As usual, if any answer is not satisfactory or you are confused or you want to ask, you can write to us. I'll take help of all the experts, those who are here, and we'll give you answer. As a ritual, we are taking the final closer remark from all the participants. So I will start with Ravi and I'll close with Kranti. What you say about the insider trading, your comments on anything and everything. Whatever we have received questions, we will pass on to the regulator and we will tell them that these are the questions which people are asking, though there must be some confusion. So if the confusion can be removed, or sometimes we are ignorant of by not reading this, so we can suggest them what they should do it. So Ravi, I will start with you. Your comments very quickly.
Yes. First of all, the regulation is inevitable to existence of securities market. Secondly, the regulation as well as the power of regulator and the action of regulator is going to increase in this area of law. Thirdly, the only solution, because the first line of defense are companies and intermediaries, awareness, running awareness programs, imparting proper training, educating people and connected persons and designated persons about the significance of this law and the sanctions under this law would prove pivotal in implementing this law. It's a very, very hard law to implement and enforce.
Okay, Moini.
Sir, adding to Ravi's, that definitely knowledge and awareness is the first thing which every company should start doing for their employees. And another thing is that the company should frame a proper internal control systems, and they will communicate these internal control systems to the concerned people, and not only the designated, they also start imparting this knowledge to the non-DPs as well, because anytime any person can possess the information. So it's best to have the internal control system accompanied with the knowledge imparting to the designated and non-designated, help to resolve the issues of insider trading.
Okay. Pankaj.
So I'll summarize the approach from the corporate side in 3 points. One would be, first would be low threshold of approval. Second would be to err on the side of caution. And third would be awareness and automation.
Okay, Savitri.
I think all the points have been well covered, and I would once again stress on awareness, because awareness is a key. This is one where the knowledge is at one end and the non-compliance happens at the other. How do you ensure that the process is fully insulated is what is more important, and therefore awareness and more awareness programs is what is required, and of course a very clear zero tolerance policy.
Okay. Kranti, your final word.
Yeah, my final word remains the same. Like Savitri said, zero tolerance policy, all right. but
Yes.
not out of a sense of fear, but out of a sense that the cost of insider trading will be too much for both the reputation of the company and the reputation of the Indian securities market, and the benefit would be simply individual, is what we'll have to always keep in mind while tackling this problem, whether the regulator, whether the legal firms, whether companies, or whether consultants. Essentially, we need to be on the same side to see what a menace this is. And the benefits it brings are individual, but the cost, cost it levels are across the market. That is what we'll have to see and appreciate.
Okay. So friends, you have heard everybody. You have seen what questions and answer. They have clarified your doubts. So we are now ending this program. And thank you very much, Kranti, Savitri, Pankaj, Mohini, and Ravi for participating and giving this. I will summarize all the questions and send it to all the participants as well as our learned speakers, and submit some queries which are there to regulator, which is not covered in FAQ. Maybe they can when they are revising this. So thank you very much to all. Friends, we are continuing our journey, and our journey of knowledge sharing will continue. So next Friday, that is on 24th June, we are organizing program on NSE Prime for long-term growth. And this program in NSE has come out. Is the hardened and some restricted compliance of some companies, and that will go to NSE Prime. So investor can safely trade in these types of company which are following more compliance. And we want to discuss the concept and how the companies are taking this particular NSE Prime, because I have seen the response is not up to the mark, because companies are fearing to go, because this require more compliances which company has to follow. So Priya Subramaniam, the Chief Regulatory Officer NSE, she will be the guest speaker, and Anjali will talk about the principal things. So thank you very much. See you next Friday to all. Thank you very much.
Thank you.
Thank you all.
Thank you.
you.
Thanks everyone.
Thank you.
Thanks.
Thank you.